Hi, good evening, everyone, and welcome to another edition of the Justice and Pieces guest speaker series. Today's guest is Elaine Page. Elaine is a previous recipient of the 2013 Law Society of Ontario Distinguished Paralegal of the Year Award. She has nearly 30 years of experience practicing in small claims court and landlord-tenant board, and as well, she's a strong advocate for education for paralegals and paralegal students. She has her prep network, which is designed to provide paralegal resources and an education program in particular to help those with the P1 exam and a lot more. So thank you so much, Elaine, for joining us here today.
I am delighted to be here. Thanks for the invite.
And to start with, Elaine, maybe you can go over your lengthy experience there. Talk to us a little bit about how you got into practicing law. And certainly, I think one of the benefits you have, and a few of the other people I've had before, the experience of being a paralegal pre-licensing and what it's been like since 2007 as a licensed paralegal, and what you've noticed, and especially because of your commitment to education there for paralegal and paralegal students, what that's been like in the last 15 or so years.
Sure. Okay. Well, I have to tell you, I nobody ever asked me this, so thanks for asking. I didn't set out to practice law. My area of interest was actually film, and I worked in the film industry, and had an accident on set. I was on a show called Road to Avonlea, and I renamed it Road to Agony, and couldn't walk for quite a long period of time. And so my father was a pretty predominant lawyer at the time, and he needed some help in his office, and I wasn't doing anything. And so I said, okay, I'll come in. And it kind of snowballed from there. I went in as an assistant, and all of a sudden they threw me a file and said, go to court. And I had literally no idea what I was doing. And I remember my first court appearance, I was asked to do an adjournment in small claims court, and I didn't know what an adjournment was. So it was very much trial by fire. But what ended up happening is, after a couple of years at the firm, I opened up my own firm in 1992. And I have been practicing on my own ever since then. And it was been a real journey, because back then we were court agents. We were paralegals. They didn't know what to call us. And there was probably only maybe 20 of us in the entire province who were actually doing this. And there were people who were doing family law. They were appearing in all sorts of other courts. And some of them did it really, really well. And some of those names, not in family law, but some of those names are still practicing today. People like Kathy Corsetti, for example. So then, as the years progressed, more and more people started joining into the profession, and it was tough because some people were really dynamite. They really had a good sense of what they were doing. They were highly ethical. They practiced and very well. And there were other people who had ethical issues, who didn't have the knowledge base. And ultimately, what happened is that the Courier report came out, and we became licensed under the Law Society. So after, I don't know, I guess about 15 years of practicing or so, all of a sudden I had to write an exam to be able to work in an industry that I've been working in. And the big change really is, and we still have a long way to go with this, but there's a level of respect now. When I used to go into a court, the judges initially treated me with a bit of disdain. They were not happy that somebody who didn't have a license to practice law was in court. We had to fight for our right to be there. And now it's very different. When you are before a court and you are licensed, there's generally a level of respect, not in all courts and not by all judges. We still have lots of work to do in that arena. One of my pet peeves is, actually, we get asked all the time, especially in the small claims court, what's your status? And I'll say, I'm a paralegal. And they'll say, are you licensed? And yeah, I always say yes. But they never ask the lawyer if they're licensed. And so sometimes I get cheeky and I'll say things like, just like my colleague, I am licensed. I'm assuming he is or she is too. So there's still we're still trying to gain respect in the legal world. It's still very much in its beginning stages. Like, we've only been licensed since 2007. That's not very long. So it has changed. And part of that change for me is being asked to um, sit on different committees. So and that's about relationship building over the years. So in 2006, I actually sat on the rules committee, which is like, I don't think there's ever been a paralegal that's done that. And that occurred because I had the respect of Justice Thompson, who at the time was the head of the small claims court, and she invited me on board. I've sat on Justice Boncalo's advisory committee on family law. And again, luckily, the honor was mine. I was the only paralegal who was on that advisory committee. When I walked into the room, we weren't doing family law, and when I walked out, she was making recommendations that we do family law. Unfortunately, it's gotten hung up at the Law Society, but it's been amazing to be able to have an influence on how law works in Ontario. And right now I'm on the COVID-19 working group for the small claims court, which is, again, another opportunity for me to set policy. And I'm doing that with my colleague, Michelle Haig. And then everybody else on that committee is either works for the Ministry of the Attorney General or they are justice. So I've had a lot of opportunity to have real input in the world, and that's been an extraordinary experience for me. I'm notwithstanding, I'm very proud of it, but I also consider myself very lucky to have been invited um, to the table in this profound way. And just last week, for the first time ever, Kathy Corsetti and I arranged LTB, Landlord and Tenant Board, stakeholders meeting for the profession, and we had the associate chair, the registrar, and various other people who gave us 2.5 hours of their time answering all of our questions. So I think it's really, really important to be able to give back to the legal community, and so that's part of what I try to do. Is I've had so many opportunities that for me it's important to share those opportunities with other people. So that's kind of who I am.
So there's a lot there, but I think what's topical for my students right off the bat is that we just finished with small claims court last week, and one of the things, we had like a mock settlement conference, and I think one of the students was just sharing that they were listening to something, and it's about learning to take it more of a dance rather than a wrestling match. And maybe you can share some of your thoughts there on let's start with settlement conference and your experience there of trying to get things resolved before they go to trial. And certainly we'll talk about your involvement there with COVID, because I think a lot of practitioners have been kind of hitting the pause button, so to speak, for almost a year now on a lot of their small claims matters. So maybe you can start by talking about your experiences with settlement conference and trying to turn those no's to yeses.
Sure, happy to. So the first thing that's important about a settlement conference is client management and client expectation. A lot of times clients want to come in and just, bash, smash, crash, and they want 100% of their claim, or they don't want to pay anything at all and admit no liability. And that's not a good place to start from, because in every claim that gets issued, there's risk for the plaintiff. And on every defense that's filed, there's risk. So you really need to spend time managing client expectations. So that's the first thing. One of the most important things that can get you to settlement at a settlement conference is actually listening. So, what do we mean by that? We're so busy trying to argue our case and shoot down the other side that we're not hearing what they're saying. And most of the time, um, especially in litigation, people just want to be heard. They somehow feel that, and maybe justifiably so, that they've been wronged and they need to be able to express that. So if you're sitting from in the defendant's seat, you need to actually sit back and listen. And then the key to it is active feedback. So um, you don't have to agree or admit to what that plaintiff has been saying, but you to acknowledge, that their position. So the way I do that is to say, I hear you when you say you were upset that this happened. I hear that. Um, and I understand why you feel the way you do. And then what happens is when someone's feels heard, again, you're not necessarily agreeing with them, you're just hearing them. So once somebody feels heard, they're more inclined to come to a resolution than if they're being dismissed. And that's really, it's an interpersonal dance. And once you can learn that dance, you'll have a much better opportunity at resolving. And so practice this when you're in situations with your loved ones where somebody's mad because you didn't do the dishes, and you didn't do the dishes because you were doing your homework. Well, so the answer is, I hear that you're upset that I didn't do the dishes. I hear you, and I know that it's a problem for you, and I respect that, and I will do them now, or I will do them when I'm finished my homework, but I hear how upset you are. And it just takes the wind out of somebody's sails, like completely, and it gets them to a place of resolution. So that's my secret trick on resolving. The other thing is, be respectful in a settlement conference. Don't look, I'll say straight out, not all judges are great judges, and some of them don't understand the issues, and some of them don't understand the law. And the tendency is to jump in and start correcting and showing off how smart you are. Um, and sometimes it's better just to step back and be respectful of the court. You'll get a lot further, and a judge will work with you in a way that's more positive than if you're telling the judge that they're wrong. So, and I see it happen all the time. So those are my tricks for settlement.
So
I just actually want to say one last thing. There are times where you go into a settlement conference and there's absolutely no way that it's going to settle. So use that experience as discovery. And so, you have to tell your client, just shut up, don't talk. I'm trying to gather information here. So what do I mean by that? I want the other side to talk. I want to hear all of the things that they're going to say, because if this is going to trial, they're going to be telling the same story. And I want to have all that information. My client may want to retort back, and because it's hard when they're feeling attacked, but if you can keep them quiet and just take in all that information, that will set you up nicely if you go to trial.
Now, thanks for sharing that. And I think you mentioned client management, and I think that's probably one of the skills that you can't really learn until you have clients. And even after you have clients, no two clients are alike. What other strategies in terms of having them kind of understand that just because you had a claim and just because you may be entitled to, let's say 35,000 now because the limits are up, doesn't mean that you're going to get it, because it could go to trial and you're going to spend, you're going to have to pay for my services. You're going to pay for various other things. You're going to have to wait. And it may very well end up that they may not have the funds, and you'll be, it's like you can print that order from the judge and put it up on your refrigerator, but you don't actually have the 35,000 in your hand. How do you convince them that, especially when emotions and tensions are running high, that practically speaking, maybe a resolution where you don't get 35,000 is in fact in your best interest? And even if it doesn't come at settlement conference, even if it comes even before starting the claim itself?
It actually often comes before starting the claim. So you have to take their story. You do an intake and you take in your client's story. And part of it is to be devil's advocate and say, okay, I'm hearing your story. Here's where there's problems. Here's where there's risks. Here's how this might get interpreted. And I know that's not what you think, but this is how a judge might interpret something. They're hearing it fresh. They don't know you. It's just fact to them. So you have to go through that with your client and explain to them that just because they believe it's so doesn't make it so. We get a lot of people who sue on quote unquote principle. Well, that's absolutely the worst reason to sue in court, because you never get that satisfaction. So often I'll walk a client through their case and say, there's a problem here, there's a problem here, there's a problem here, and you have risk. So I know, especially if it's a claim under $10,000, I know that you don't agree with me, but put aside your emotions. This is a business decision. The best that you're going to do at trial is $8,000. The worst you're going to do is zero, with costs against you. If we go to trial, it's going to cost you, depending on the case, $1,500, $2,000. So from your $8,000, you're now at six. We have an offer on the table. We can probably settle this out at $5,000. Plus, you're going to lose time at work and all of those other things. So this is a business decision based on odds. What makes the most sense? Does it make sense to not incur all of those legal expenses and have $5,000 in your pocket today? Or does it make sense to go to trial and maybe you'll win? And even if you win, you have no guarantee of collecting, plus you're going to be paying me. And one of the things I always tell my clients, and this kind of goes a long way, is I'll say, the reality is I make more money if we go to trial, and I like to make money. I really do. But it's not in your best interest for me to do that. And so, when they're hearing their legal advisors say, don't go to trial, even though I have a vested interest in going to trial, that often will turn their heads around. It also gleans a lot of respect, and that's important.
Now, you were talking about the COVID committee there that you're on. Perhaps you can share. Well, one of the things certainly is now navigating, for my students, navigating studies remotely, but for everyone that's practicing, whether landlord-tenant board and small claims matters, it's doing motions and I believe trials now over Microsoft Teams or Zoom. What can you share about? Well, first of all, I guess you're shaking your head there, so I'm guessing there are no trials. But what can you share about what's going on?
Okay, yeah, okay. So there are two separate entities. So I'm going to speak generally about it, and then I'm going to separate the two entities. So generally, all hearings are remote hearings. Generally, the government was, I'm going to say, caught with their pants down. It's maybe not an fair assessment, but nobody ever expected this to happen, and that we would have to ramp up into a virtual court. It just was not on anybody's radar. So the board handled it one way and the court handled it another way. And there's a lot of reasons for that. The landlord and tenant board, is its own separate entity. They have a significant budget. They have different resources, different staff, and they've been able to move much faster, although I have colleagues who would disagree with that statement. Much faster in getting hearings done remotely. We have been doing them on Teams, and it's worked. There's been some problems because there's been some tenants' rights groups that have been infiltrating and the team hearings and shutting down the sites and stuff. The board will be moving to Zoom in the next 2 weeks. So all of our new notices are going to a Zoom format. The court is a very different story because there was an existing e-file system that had limitations to it, and it was really for only issuing claims. The court system, their computer systems were about 25 years outdated coming into COVID. They had, in the small claims court, they have a system that they manage files on called Frank. And Frank is actually short form for Frankenstein because it was a conversion of several different programs that was instituted about 20 years ago. So you can imagine the technology challenge in trying to manage all of that. On top of that, the courts themselves were not set up for physical distancing. Um, if you've been in the court offices in Toronto, for example, there's a fairly substantial staff, and they're all sitting very close to each other. And so we certainly couldn't bring in staff. In the other courts, in the small claims court, Toronto is unique, as well as Richmond Hill, and there may be another one where they're their own small claims court in their own building in their own space. Every other small claims court office is part of the higher court office. So now we're bumping into staff for small claims court, staff for higher court, all of that kind of stuff. And it was an absolute nightmare. And I have to say that from the starting point, which was, being 20 years behind in terms of technology at the court, to where we are today is nothing but a miracle. And a lot of people will think it's moving fast enough, but they just don't understand what's involved in moving a system 25 years forward in the space of a year. They just don't have any clue what that entails. So the small claims court is working very diligently on opening up more virtual hearings. We have settlement conferences now, motions, assessment hearings. A new portal has just opened up called Justice Ontario portal, which allows us to file pretty much any document online, so we don't have to go to court offices anymore. It's got some glitches. We're working through them. Eventually, we will start doing trials again. They'll be done virtually. Right now, what we're looking at is any trials that were continuations are being scheduled first, and then eventually it will open up into a fuller spectrum of trials. So it's tough. It's really tough. And in some ways, once we get all this work done, it's far more efficient for me to issue a document from my desktop than to stand in line for 3 hours at the court waiting to get served. So I for one, am loving being able to do it off my desktop. It's going to take some time. I don't see the courts coming back to in-person hearings until I don't have a date. But there has to be a vaccine. I think when we're in a place where people have double doses of vaccines and the numbers of the risk level is significantly low, I think at that point we'll be coming back, and whenever that is, because with the variants out there, we have no idea. So we're moving towards virtual everything at this stage.
You mentioned certainly in hopefully in the near future that we can have in-person hearings again. Do you think, though, with all of these changes, that there's always going to be a place for things to be done virtually, and that, for example, for students, they had a settlement conference there virtually last week, and is that going to be kind of the norm for a lot of motions and settlement conferences?
The answer is officially, I don't know, but I sure hope so, because from a business standpoint, I now can practice anywhere in Ontario. So that's been a business shift for a lot of us, where we were bound by the jurisdiction that we live in. So for me, I'm in Thornhill, so I would cover the GTA and maybe as far north as Barrie. maybe Hamilton, but I wouldn't go further west than that, and Oshawa-ish. But now, if we stay virtual, I can, if I have a file that's in Thunder Bay and I can do it virtually, that's an amazing thing. So it actually opens up all sorts of business opportunities for people, which is great. Do I know if that's going to be permanent? I don't know. We haven't discussed it, to be honest with you, so I don't know.
And with that, it certainly poses some challenges of getting, introducing exhibits or evidence and questioning witnesses and things like that. So I guess maybe if it came up in the context, and I don't know if you're even allowed to disclose it there, but concerns like that when you're looking at temporary measures here for COVID. I mean, I've had paralegals and lawyers on both sides of the equation, some mentioning exactly what you said, others thinking, I don't feel so comfortable. Maybe they're being coached off screen and things like that.
Yeah,
What
I
are
hear
your
that all
thoughts
the
about
time.
that?
So we have talked about that at the committee level, and the reality, I mean, people can be coached in a courtroom as well. I mean, I've seen legal professionals, do this, which means to witness, which means answer no. I mean, I've seen all sorts of so the thing is that once you're licensed with the Law Society, you have an obligation to respect the court process, and you are an officer of the court. So if you're caught coaching a witness, I mean, you can expect to be out of the business very quickly. Is there a risk? Of course, there's a risk, but as I say, there's a risk. Um, there's a risk in in-person hearings too. Um, I have had scenarios where I've had people behind me in the courtroom while I've been arguing a case who send me a text message going, "Do you realize that the witness just lied or asked this question?" I mean, and that's not proper either. So yes, we are concerned about that. There are some safeguards that we're putting in to the best of our ability, but if people want to cheat, they're going to cheat. My caveat is, if you get caught, you can consider, you will have the court will no longer respect you, and all those judges talk. They all talk to each other, and you risk losing your license.
And you think in terms of advice for students and those listening about working and delivering remotely, is there a difference, do you think, and what should you be focusing on? I mean, I think for me and in the instructor side, it's the difference is you don't really see everybody anymore. So, and you don't get that kind of feedback. So you got to just assume if people understand by kind of writing questions and things like that. But in a court setting, what do you think is going to be the hardest, or what you've seen the hardest to deal with when doing things remotely?
Body language is hard. I mean, I'm a big reader of body language. So when I have a witness who's I've done a ton of landlord and tenant board cases virtually, and so if I have somebody in person, I can read their body language and know whether they're lying or not, or how they're responding to a question. And a lot of times with the virtual hearings, people are doing them on the phone, so you really miss that piece. There's also issues around evidence. I've had adjudicators who don't know how to use the technology, and you've sent your evidence in and they can't find it on their computer, or they don't know how to access it. So they do this. They're like, hold it up so we can all read it. And I mean, you can't possibly do that. Um, so what I would tell students now, particularly at the landlord and tenant board, the hearings are public. If you can get on to, if you can get the links to the hearings, you should be observing them as much as possible. And, we're having discussions about that at the small claims court. Certainly settlement conferences are not public because they're private in nature regardless. But when we get to trials and such, I'm hoping that we can have the public access available. So my advice is, to jump onto as many hearings as you can and watch and learn. See the things that we're struggling with. as advocates, see the things that the adjudicator is struggling with so that you can assist the adjudicator. That's how you learn.
Yeah, perfect. Thanks for sharing that. I think I want to try to look at getting some links, because one of the things that are missing over the last years, we used to be able to go, to 47 Shepherd there
Right.
and watch some small claims proceedings, or the various landlord tenant board sites, um, and Old City Hall for POA and criminal. So, I think that if that is possible, and certainly I think today a great example, you had the decision in Manassian that was streamed over YouTube, just like we're doing here today. Um, if you were lucky, you would have squeezed into the courthouse there with bumping elbows with the Toronto Star and all the reporters
Right.
to get a seat there. But today I don't know what the numbers were, but I'm off the top of my head exactly what it peaked at. But thousands of people got a chance to listen to that decision.
It was, I saw the numbers. I think it was 6,000 people were listening to that. It was like crazy. So, that's, as a practitioner, like it is a little nerve wracking sometimes to know that I certainly don't have 6,000 people watching my cases, but sometimes I have six. And usually when you're at 47 and you're arguing a case, there's nobody in the courtroom but you and the parties. So it's kind of odd sometimes to have an audience. It's like, it feels really strange, and you have to kind of just put them away and pretend they're not there and do your job and be focused. But on some of the Facebook pages, people do put in the links to their hearings, so you can certainly join in and watch.
Perfect. Thanks for that. And the other aspect, I think I do see a question here from one of my students, I guess related to maybe getting information from your client. So they sign a retainer, they get, you explain to them, hey, I need these documents so we can look at whether or not we have a strong case and things like that. How do you deal with, the lazy or sort of the lackadaisical client who's like, oh, I'll get that to you tomorrow, like some of my students who are listening about an assignment or something. What do you do to get them to get you what you need to start preparing for their case?
That's a great question, because it's true. We get people calling frantically, I want to sue, I want to sue. And then you ask them for the information, it doesn't show up. So I think you're always trying to cover your butt, right? Because that's the person who's going to file a complaint against you because you didn't file. So do everything in writing. You would write to them and say, I'm happy to start your file. This is what I need. And remember, you might be bumping into a limitation. There's a limitation on this, so I need it by this date. And then you flag it. And on that day, if you don't have it, you write to them again. And after the third time, I would say to them, I can't, I can no longer assist you if you're not prepared to, participate in your legal case. If you'd like me to continue on, I'd be happy to, but you need to send me these documents today. Otherwise, we will end this retainer. And usually they're like, oh, I didn't realize it. Oh, all these excuses, and then you get it on your desk. But paper it, because that's the person who's going to file a complaint against you at the Law Society.
Thanks for sharing that. Now we were kind of switching, I guess, over to the landlord tenant side, and we talked
Right.
about settlement conference in the small claim setting. Now, I mean, one of the things that was always fascinating, I guess, when you were at the board is you come. Do you want to go for the mediation there? That you say yes, they say yes. You go into the room. It likely doesn't end up going to the hearing that day. How is that done in Teams, I guess, or I guess now they're switching to Zoom, but
Not. It's
it's
not.
not.
So what's happening in this moment, and it will change in Zoom. In this moment, most of the cases that are not arrears of rent cases, they're setting up what's called a case management hearing with dispute resolution officers. And they function very similarly to settlement conferences, where we put the issues out on the table, we deal with housekeeping issues, And often we get to a settlement, and that settlement can be by way of an order on consent. If it doesn't, then it goes to a hearing, and there is no mediators at hearings in the moment because Teams does not have the functionality to be able to do that. Zoom, what we were told at the stakeholder meeting, though, is that once we switch to Zoom, that we'll be able to do breakout rooms with mediators. So we're really looking forward to having that ability to do that, especially on L1 hearings for non-payment, because so many people have been affected by COVID, and we really want to make payment plans with those people, and there's no opportunity to do it. So if we have the mediators there, at least we have a shot.
That's great to hear, and hopefully that results in more things being able to resolve. The other piece there, certainly that I know last week students wrote the licensing exam, and I certainly wanted to give some time for that because I know a lot of my students who just finished the program who've been helping out here tremendously, and I think what they're really wanting to look at is how do we start preparing for the P1 exam I think the next sitting is July now. And I know you have a fabulous program because I think some of my students have gone on to do it. And certainly in COVID, a little bit differently with the exams being remote. So maybe you could start by just talking a bit about what you offer there for paralegal students and
Sure.
some general advice about preparing for the P1 exam.
Sure, be happy to. So I have a company called PrEP Network, PREP Network, which stands for Paralegal, I always forget, Education Resource Program. I very rarely, it's just always been PrEP, and I always forget what it stands for, which is terrible. But anyway, so as I said, I wrote the exam in 2007. And what was happening for me is I had been practicing for all of these years. Suddenly I was forced into writing an exam, and I had no idea how to study for it. And at the time, my father had had a massive stroke. So I was spending all this time at a hospital with him trying to study. And I had a friend who was a professional educator with TDSB for many, many years. And I was freaking out. And she said, "Give me your material, I'll help you." And I thought that was pretty arrogant of her to assume she knew anything about law. But after 20 minutes, she put me on a program and said, "Here's what I want you to do." And over the next 2 or 3 weeks, she would add different pieces to that program and made it a breeze for me to study. And so she and I took all of those pieces and put them together and created the PrEP Network exam prep course. She's since retired, lucky bum. So I've taken it on myself. So we go through, how to study. Most people just don't know how to study. They've never been taught that. And how to retain information, because when you get the material, there's literally 800 pages of very boring, dry material. And how do you lift that off the page and retain it? And that's the tough part. So the trick in doing all of that is to understand the kind of learner that you are, because everybody has different skill sets when it comes to learning. There's no wrong way or right way to learn, but there might be a wrong way or a right way for you. So what I do is I walk you through different pieces to determine what kind of learner you are, whether you're a visual learner, an auditory learner, et cetera, et cetera. And then we build on those skills so that ultimately what you come out with is a method to study for the exam that works for you. And it may not work for your friend because they may not be the same kind of learner as you. And it teaches you how to retain the information and how it will make sense for you. So that's sort of part of what we do. And then we spend quite a bit of time breaking down what a multiple choice exam looks like in the context of Law Society. And there is a format and a formula for multiple choice questions. So we break that down so that if you're in a situation where you have to guess, you've got a really good shot at guessing correctly. The other piece of it is showing you how to set up your material so that you have these 800 pages. If you actually had to look up an answer, you should be able to find that answer within that 800 pages within 20 seconds. And I teach you how to do that so that you're not wasting time flipping through 800 pages trying to find an answer to something. So we've been doing that for a while, and I've been doing it for 11 years now, and I've had well over 1,000 students. I don't guarantee success because I can't possibly do that. It's like my court cases, I never guarantee success. But we've had really good results. The people who have taken it have been stunned at how much easier it is and how much more confident they are having done the course. So it's a lot of fun for me. I generally run the course a month before the exam, so it gives you enough time. In the meantime, because you don't have the material now, basically the new material comes out usually around the end of March or April, and that makes it tough for people who are writing in July, August, because it doesn't give them as much time. So since you have students who just wrote, they will still have access to their material. The material doesn't change that fundamentally. So I would see if you could get your hands on the old material and start studying from the old material now and really give yourself a leg up.
Now, one of the things I thought that was brilliant there is students not knowing how to study. And I think that even in our paralegal program, we have a lot of primarily multiple choice based exams to kind of help prepare you. And the timing's pretty close sometimes to what you have there at the Law Society. I think now it's a 4-hour exam, and I can't remember the exact questions. I think it works out to about 90 seconds a question, which is very little time to read a question, read the choices,
No,
try
it's
to
not.
find the answer.
No, it's
Then,
not. Not if you do it the right way. It's quick. Sorry, I hear that all the time. And one of the things I do is I give people a short exam and using that time frame, and usually the last 4 minutes they're sitting there doing this, and it's to get a sense and a feel of what that time is like. So yeah, I mean, I don't mean to be disagreeable, but if you're prepared, you know those answers in 90 seconds is tons of time.
yeah, I guess what my question was how do you get from the students who think it's not enough time? Because when I had students write and they're telling me, yeah, I had an hour afterwards to go back through those questions, but when we were preparing, I thought that there was no way I can do all this in 90 seconds. So how do you make that conversion to being overwhelmed with the time to then being twiddling your thumbs at the end? What do you think is the best strategy to get through that quickly?
It's about really being secure in the material. So if I were to give you an exam that is about something that you've been doing all your life that you know well, you'd be able to just go through it real quick. So if you're confident that you know the material well, time is no longer a problem. And so the real trick is to know your material, because you don't have time to be looking up stuff. If you know the material, you shouldn't have to look anything up. And hopefully, best case scenario, you may have to look up 3 or 4 things. But it's really knowing that material. And there's all sorts of tricks to learn how to know that material well. So part of what I teach is things like recording your voice. If you're an auditory learner, read it out loud and record it on your phone, and then go for a walk and listen to it. Take every situation you take in your life, walking down the street, interactions with your family members, convert that into a scenario question and test yourself. There's tons of opportunity to bring stuff to life. And so the best answer around time is knowing your material well. I mean, I will tell you, when I wrote the exam, it was before the substantive portion kicked in, and it was a 4-hour exam. I finished in 56 minutes. It's because I really knew it, not because I'm so brilliant. It was like asking me what my name was. It was just stuff I knew. That's where I want everybody to be.
And it certainly takes um, not leaving it to the last minute, so to speak, to try to read through the material there.
Yeah, I saw a post the other day about somebody's, how did you study for this exam? And someone said, do the stuff you like first and leave the stuff you dislike to the last. And I thought that was like not great advice, because if you leave that to the last, you'll be cramming it. And the reason you don't like that stuff is because you don't know it and you don't understand it. So really, that's where you should be focused on. So um, if anyone wants to start studying now, start studying on the courses you hated the most. That's a good place to start.
Perfect. And thanks for that. And certainly, um, what about doing, I guess you were mentioning practice tests and previous students, or I think help kind of come up with some questions there as part of, I think, your program. How do you think there's a correlation between doing those practice exams and then writing the actual exam?
So that's a great question. It really depends on what questions the practice exams are. There's a number of people who've kind of jumped on the bandwagon and have created practice questions. Some of them are good and some of them are terrible. And if you are answering really bad questions and getting them wrong, your confidence level goes through the toilet. And so I don't necessarily recommend them. For that reason. And I will also tell you that a lot of the questions that students have written on exams in in their school have not been great questions. They haven't been written well. There's actually an art form to writing exam questions. The better thing to do, and there's incredible learning in this, is to actually write questions for yourself. Because in order to write a good question, you have to really understand the material. So I prefer a study group of 4 or 5 people who each undertake to write 4 or 5 questions each for each session, and then create their own exam for that little session for themselves. You can't believe how much you learn by writing out, creating questions. It's an opposite way of learning the material.
Perfect. So thank you so much for joining us here today, Elaine, and sharing so much different advice there from small claims and landlord intent, and certainly for those who are about to embark on getting licensed in the P1 exam later this year. I was wondering if you have any final words of wisdom here for my various students, whether they're just starting the program, like some of them who are just finishing small claims and are about partway through the program, or the ones who just finished. And certainly there's probably some practitioners listening as well. What are some advice? What are some words of advice that you can share about becoming successful paralegals? I mean, it's not just passing the exam, because you obviously want to go and practice.
Yeah. Thank you. This is a great question. So I always tell people that in all my years of practice, I've never actually won a case. I've never lost a case either. My clients have won, my clients have lost, but I've never done. I haven't had any personal litigation. And the reason that I separate that out is because it isn't about me. It is about my clients. And I am of the firm belief that as legal professionals, we are in the service to our clients, and that's what we're providing them, and service to the court. And when you take that approach, you're able to have that break you need and not personalizing every case. But it also allows you to see the big picture of what's going on, um, and be a stronger advocate for it, because it is not about you, it is about your client always. So that's one of the takeaways that I always tell students, just to remember that it's so critically important. I'm also going to tell you that over the years I have met some of the most extraordinary people, whether it be colleagues or clients, It's been such a joyful ride. Yes, there's been moments of frustration, but to stick with it, because it's such an amazing profession to be in. And I do feel very blessed to be part of it still, even as I'm thinking about retiring. When I think about the opportunities that I've had, about the people I've met, the relationships that I've established and enjoyed, it's worth all the agony you guys are going through now. It can just be a tremendous profession. And so I'm going to wish you all success.
The last question there, I just wanted to, I forgot to ask it a little earlier, but looking back now, because you were mentioning thinking about retirement, now it's 2021, and I think you go back into the, the days of, I think you mentioned Road to Avonlea there, getting into the profession there. What have you noticed in terms of such a big amount of change over 30 years? I mean, I guess outside of Frankenstein software there in the court there, but what can you see in terms of all your years of experience about the profession, and specifically now being licensed versus what it was like in the 90s and 80s?
Respect. It's all about respect. We still have a long way to go in terms of gaining respect, particularly by our lawyer colleagues who don't always give us the respect that we deserve. But the biggest change for me is from sort of sheepishly standing in court going, I'm here, to being very proud of the profession and to have garnered the respect of the judiciary, of the adjudicators, of the attorney general. We are a recognized, powerful force, and we've come from nothing to that. And that is a huge change. And we still have a long way to go, but it's a wonderful change.
Perfect. So thanks again for joining us today. And certainly it makes it a lot easier for my students and people listening to help get that respect from from my colleagues at the judiciary, because of people like you have helped pave the way. So thank you for that, and wish you all the best with everything that's going on. And thank you for everyone tuning in. And certainly please stick around after a little quick break, because we have Amy Rodriguez joining us at 6 o'clock. Take care, everyone.
Thank you. My pleasure. Be well, everyone. Stay safe.
Thanks, JP. See you on the other side.